This hearing of the IP Subcommittee of the Senate Judiciary Committee will come to order. Thank you to all of our witnesses on the first and second panel for participating today. I apologize for being a few moments late. We are in the middle of a two-vote series, so all of us will at some point get up and go vote and come back. My hope is we'll be able to continue this hearing regardless. I'd like to particularly thank my ranking member and friend, Senator Tom Tillis, and his staff for continuing to work so well together and putting this hearing together on a consensus basis. Today we are examining the Patent Eligibility and Restoration Act, or PERA. This is our second drive through this thicket, and I'm looking forward to a return, not just of many of the witnesses from our previous hearing, but to a reconsideration of many of the core issues. PERA would reform U.S. patent eligibility law. More than 70 years ago, Congress passed the Patent Act, and that law defined patent-eligible subject matter very broadly. The legislative history suggests that Congress intended to allow anything under the sun as made by man to be patentable. Other provisions in the Patent Act requiring a new invention be novel, non-obvious, have a written description and so forth, served as the fine filters to patentability, and eligibility was a coarse filter. That all changed roughly a decade ago when the Supreme Court announced a new two-step test for determining patent eligibility. Patent examiners and judges have to determine whether an invention is directed to a patent-ineligible concept, like a law of nature or an abstract idea. And if so, the examiner or judge then has to consider whether the patent claims contain an inventive concept. The result, fewer inventions are patent eligible in the United States, particularly in rapidly advancing fields like medical diagnostics, software, artificial intelligence. However, those same inventions are still eligible for patent protection abroad, which means if innovators and investors don't have confidence in our ability to protect inventions here in the United States, they may or will take their skills and investments elsewhere. This new test doesn't just put the U.S. at a competitive disadvantage, it is also quite difficult for judges to apply with any degree of certainty. Here's how judges on the Federal Circuit, the country's specialized patent court, have described the state of U.S. eligibility law: incoherent, fraught, unclear, inconsistent, and confusing. Things are so bad, the Chief Judge of the Federal Circuit has made an unprecedented plea for guidance to the Supreme Court. Multiple solicitors general of the United States have asked the court to clarify this law, this area of jurisprudence, and the Patent and Trademark Office has asserted that the legal uncertainty from the Supreme Court's decisions has caused the agency unique challenges. In 2019, Senator Tillis and I held a marathon 3 days of hearings and heard from 45 witnesses on the issue of patentability. Almost every witness agreed that eligibility law was a mess and needed further clarity and guidance. The Supreme Court has consistently refused to step in, denying every one of the roughly 100 cert petitions raising this question over the past decade. With the Supreme Court unwilling, unlikely to act, legislation is the best and may be the only path forward, which is why I was happy to once again join Senator Tillis in introducing PERA. PERA will return eligibility to important inventions like biotechnology, medical diagnostics, 5G, AI, blockchain. It will also make clear what is not patent eligible: mere ideas, discoveries of what already exists in nature, like unmodified human genes, and social or cultural content, things that everyone agrees is beyond the scope of our patent system. The bill would accomplish this in 3 ways. First, PERA would abolish judicially created exceptions to patent eligibility, including those set forth in the Supreme Court's two-step test. Second, it would clarify that eligibility determinations are to be made by considering every claim element of the patent as a whole and without regard to the novelty, non-obviousness, and disclosure requirements. And third, it would set forth a specific but extensive list of excluded subject matter while maintaining the existing statutory categories of eligible matter. I look forward to continuing this work with Senator Tillis and with the wide range of stakeholder groups represented by witnesses here today as we move forward with PERA. With Senator Tillis's cooperation, we've assembled 2 panels with diverse views and perspectives, pro and con. And I encourage our witnesses to be direct about what they like about the bill or to be specific about what they'd like to see changed in the bill and why. I'll introduce this first panel of witnesses in a moment, but first I'll turn it over to Senator Tillis of North Carolina.
Thank you, Mr. Chairman, and thanks everyone for being here. Patent eligibility and PTAB reform are two of the most significant issues that we must address within the patent community. Today we focus on patent eligibility reform. And while I do believe that I don't always believe that the best fix is a legislative fix, I think we reached a point to where legislation is needed. As a result of a series of U.S. Supreme Court decisions which created categories of judicial exceptions, patent eligibility law has become confused, constricted, unclear over the years. This has led to inconsistent case decisions, uncertainty in innovation and investment communities, and unpredictable business outcomes. This lack of clarity threatens to hinder innovation and to unseat the United States as the world's innovation leader, especially in new and emerging technology sectors as precision medicine, artificial intelligence, quantum computing, and 5G wireless and beyond. This impacts individual inventors and businesses, both large and small. Furthermore, this lack of clarity has the potential to cripple our economic growth and will leave our country vulnerable to foreign bad actors, primarily the Chinese Communist Party, who wish to undermine IP rights. In 2021, I worked with David Kapos and Judge Paul Michel to file an amicus brief in the American Axle case. I was disappointed to see the Supreme Court decline this opportunity to offer clarity on patent eligibility. This is yet another reason why Congress must act, and is why I, alongside Chairman Coons, introduced the Patent Eligibility Restoration Act of 2023, or PARA. This bill will restore patent eligibility to important inventions across key areas of technology. PARA maintains the existing statutory categories of eligible subject matter, which have worked well over 2 centuries, and addresses concerns regarding inappropriate eligibility constraints by enumerating a specific but extensive list of excluded subject matter. This reform will directly and meaningfully impact all stages of patent life cycle, from prosecution to litigation. I look forward to continuing the work with stakeholders to develop a proposal that strikes the correct balance, and most importantly, which can pass the Senate and become law. I encourage everyone to reach out to engage with my office regarding this bill, especially those who oppose it. And again, I'm going to make my traditional disclaimer. Just come at us with good arguments. Don't try and undermine it behind the scenes. It never ends well. We've said many times before, it's better to be at the table than on the table, and I'm going to say it again. Be at the table. Let's get this right, because oftentimes when you come with a point of view, with the data to back it, then we're going to try and accommodate it. Mr. Chair, thank you again for holding the hearing. I look forward to continuing to work closely with you and your staff to move both PARA and Prevail through the Senate together. And now I look forward to hearing your testimony. Thank you, Mr. Chair.
Thank you, Senator Tillis. Thank you, Senator Hirono, for joining us. We hope to have other members of the committee come as well. Today we welcome 2 panels of witnesses to testify about PARA. Our first witness is Andre Iancu, partner at Sullivan & Cromwell and former Undersecretary for Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office. Welcome. We second have Richard Blaylock, a partner at Pillsbury Winthrop and an IP strategist for a genetic testing company Invitae Corporation. Thank you, Richard. Next, we have Courtney Brinkerhoff, a partner at Foley & Lardner, who's been advising international life sciences clients for more than 25 years on obtaining, defending, licensing, and enforcing patents. And finally, we'll hear from Phil Johnson, Steering Committee Chair of the Coalition for 21st Century Patent Reform, or 21C, a coalition of American patent owners and manufacturers from a wide range of industry sectors. Mr. Johnson has been a leading voice in patent law for more than 40 years. Briefly about the mechanics, after I swear in this panel of witnesses, you'll each have 5 minutes to make an opening statement. We'll proceed to question. Each senator will have 5 minutes. We will likely have a second round of questions. Then we'll recess and bring in the second panel. But first, to be sworn in. Could all the witnesses please stand? Please raise your right hand. Do you swear or affirm that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Mr. Iancu. You may proceed with your opening statement.
Thank you, Mr. Chairman, Chairman Coons, Ranking Member Tillis, Senator Hirono, members of the subcommittee. Good afternoon, and thank you for the opportunity to discuss PIRA. I want to start by particularly thanking the subcommittee for undertaking the critically important task of modernizing the statute, which in essence first appeared in the Patent Act of 1793, written when Madison and Jefferson were drafting patent laws. A lot has changed in the world of technology since 1793, and courts and the USPTO will be forgiven for struggling to apply an 18th century statute to 21st century technology. Our founding fathers were brilliant, but even they did not anticipate DNA processing or the internet. The current state of Section 101 law is the result of many court decisions over the decades trying to determine whether these modern technologies fit into categories defined in 1793 or whether they are subject to certain exceptions courts have imposed since then. These court decisions also have resulted in certain de facto rules, such that diagnostic techniques, for example, are generally not eligible for patent in the United States, that Congress has never considered, debated, or passed into law. If the United States is not to recognize patents for certain categories of inventions that would otherwise be part of the categories outlined by Congress, then it is up to Congress to make that rule. In other words, Congress defined the categories of invention that are eligible for patent. If there are to be exceptions to those categories, they must likewise come from Congress. One of the biggest errors in the current jurisprudence is that court decisions have recently imported into Section 101 analysis concepts from other parts of the patent code, such as questions of novelty, which should be dealt with in Section 102, questions of obviousness, which should be addressed in Section 103, and questions of specificity and disclosure, which should be addressed in a Section 112 analysis. All this has even sown confusion among the expert ranks of the hardworking patent examiners at the USPTO. To address this issue, the Patent Office promulgated guidelines in 2019 that synthesized the relevant case law and provided examiners and applicants a significantly improved framework for analyzing eligibility under 101. This has dramatically improved the analysis at the USPTO. For example, a study by the office's chief economist has shown that uncertainty of Section 101 decisions for the relevant technologies decreased by 44% in just that first year following publication of the guidelines. It's working really well. Courts, however, are independent and not bound by administrative guidelines. So they persist. They persist in their approach, which has caused profound uncertainty in the lower courts and among inventors, investors, and patent law practitioners alike. As a result, congressional action is needed to determine affirmatively which categories of invention should be deemed as statutorily patentable or unpatentable. Here is the most important point. Congress needs to create clear rules. Whatever those rules may end up being after the legislative debate, at least the public deserves to know what the rules of the road are. Fortunately, PIRA provides a legislative vehicle for the United States to correct the state of the law. PIRA outlines a correct three-step framework for analysis. First, PIRA maintains the broad categories of what qualifies as an invention in the US, in other words, what is in the patent system. PIRA then expressly outlines certain categories that are not considered to be eligible for patent, in other words, what is out of the patent system, and further indicates that courts are not to create any other exceptions that are not in the statute. Third, PIRA clarifies that excluded matter does not automatically destroy eligibility. Specifically, an invention that combines excluded matter with eligible matter into a useful, practical application, then that combination may still be eligible. In the end, once the categories of included and excluded matter, after debate and adjustment as appropriate, are settled on and passed into law, PIRA will bring immediate certainty to Section 101. I commend the subcommittee for holding this hearing to bring much-needed reform to Section 101 and to set our nation on a path of innovation and success for the 21st century and beyond. Thank you again for the opportunity to testify, and I look forward to your questions.
Thank you. Thank you for your testimony. Mr. Blaylock.
Chair Coons, Ranking Member Tillis, and other members of the subcommittee, thank you for the opportunity to address the topic of patent subject matter eligibility. I'm appearing on behalf of Invitae Corporation, for whom I've been outside corporate and intellectual property counsel since its formation in 2010. Invitae and the clinical diagnostic community it serves is concerned that the Patent Eligibility Restoration Act, or PARA, as introduced, would stifle innovation and harm patient care in the fields of diagnostic genetic testing and precision medicine. Invitae is a leading medical genetics company and delivers clinical, actionable genetic information for both children and adults. Invitae has served over 4 million patients, and its success in providing critical genetic information has been fostered by the current patent eligibility jurisprudence in the United States. We have often heard the suggestion that the publication of the human genome has rendered moot the need for concern about patents related to human genes. The argument rests on the idea that the risk of patenting human genes has passed because the sequences of human genes are no longer new. This represents a fundamental misunderstanding of the risks to science and patient care caused by permitting natural phenomena to be patented. Under current law, natural phenomena are not patent-eligible subject matter, nor are applications of conventional technology to natural phenomena. No person has the standard human genome. All of us have variants in our genetic sequences. Some of these variants are clinically significant. A well-known example is a collection of variants in the sequences of the BRCA1 and BRCA2 genes that, when present, indicate a substantially elevated lifetime risk of breast cancer, pancreatic cancer, prostate cancer, or other types of cancer. Variants such as these are natural biomarkers, and this information, including its association with disease risk, is an unpatentable natural phenomenon. Similarly, the application of conventional sequencing technology to detect the presence or absence of such biomarkers is unpatentable. By contrast, nothing in the current law impedes the patenting of new diagnostic techniques, such as new tools for sequencing genes. While some important biomarkers have been discovered, the human genome is vast, and far more important biomarkers remain to be discovered. Our increasing sophistication in understanding these biomarkers and their clinical relevance is essential to the practice of personalized medicine. The absence of patents on natural phenomena has not impaired innovation in the genetic diagnostics industry. Quite the opposite is true. In the last decade, the genetic testing industry has thrived. The cost of genetic testing and genetic sequencing has fallen dramatically. There are no barriers to innovation in detecting new, clinically relevant biomarkers. New biomarkers are being recognized on a routine basis. PARA would permit the privatization of natural phenomena in the form of knowledge about human health and disease risks, such as that embodied by genetic biomarkers. PARA would slam the door shut on innovation and its clinical application in medicine. A new patent thicket covering newly discovered biomarkers would appear and impede patient access to such basic information. Because so many are engaged in identification of new biomarkers, a diverse group of new patentees would stand in the way of a clinician's effort to conduct an analysis of a patient's genetic information, because state-of-the-art clinical testing would require permission from all of them, none of whom would be required to grant such permission. That was the reigning set of conditions before the Mayo, Myriad, and Alice decisions, and PARA would take us back to a time when the toll charge for access to biomarkers in just the 2 BRCA genes was $4,400. Today, a test yielding far more information costs only a fraction of that amount. The patent system should afford the opportunity to own the cure, but not the disease. Variants such as these are natural biomarkers, and this information, including association with disease risk, the patent system does not now and should, the patent system does now and should permit the protection of inventions, but not mere discoveries of information. And it does and should reward innovation in the form of new therapies and new tools for detecting biomarkers, but not the biomarkers themselves. We urge the subcommittee to recognize natural phenomena such as biomarkers as pre-competitive information available to all. This can be accomplished by revising PARA to include the requirement that natural phenomena, natural materials, and abstract ideas be treated as prior art to all patent applications. This would be the most efficient way to effectively codify the essence of current Supreme Court jurisprudence on patent subject matter eligibility. Invitae stands ready to offer any assistance the subcommittee may request in order to approach patent law reform while preserving the vitality of the genetic testing industry, innovation, and importantly, patient access to the promise of precision medicine. Thank you.
Thank you. Ms. Brinkerhoff.
Chairman Coons, Ranking Member Tillis, thank you for the opportunity to speak on this important issue. I am providing comments from the perspective of a practitioner with many years' experience helping clients in various life sciences industries obtain patents on their inventions. But I think I'm the first one who has to include a disclaimer that my testimony is personal to me and should not be attributed to any of my clients or Foley & Lardner, its partners, or its clients. I want to touch on 3 issues: international inconsistency, the impact on microbial technologies, and ongoing uncertainty. Since Mayo, Myriad, and Alice, there are inventions that cannot be patented in the US that can still be patented in other countries, including Europe, Japan, and China. These include most isolated natural products, such as vaccine antigens, therapeutic peptides, chemicals isolated from plants, and bacteria that are useful in commercial and industrial applications. With regard to diagnostic methods, although some countries have limited exceptions on public policy grounds, most still grant patents on methods of detecting new diagnostic markers, such as the claims invalidated by the Federal Circuit decision in Sequinome. Because you have to disclose your invention to obtain a patent, this means that inventors have to disclose their inventions to the whole world, but cannot protect them to the same extent in the US. As I understand it, PARA would bring the US eligibility back in line with patents that can be granted in other countries. The current imbalance in the quid pro quo of disclosure for patent rights is particularly acute for technologies related to microorganisms, such as bacteria useful in brewing, baking, production of dairy products, oil and plastic degrading bacteria, carbon dioxide fixing bacteria useful in environmental remediation, just to name a few examples. In order to satisfy the written description requirement for a patent, the inventor has to deposit a sample of the bacteria with a facility such as the ATCC in Gaithersburg, Maryland, and then has to make samples available to the public when the patent grants. Even if the patent only covers a specific method of using the bacteria, samples have to be made available to the public. Prior to Myriad, a patent could be obtained on the isolated bacteria, but post-Myriad, the possible scope of protection is more limited. This imbalance, requiring a physical specimen but not granting an equivalent scope of protection, disincentivizes patenting in this area and makes trade secret protection more attractive, especially when the bacteria can be used in-house. I think it's important that PARA restore eligibility in this important space to encourage continued investment in innovation. Turning to the continued expansion in the judicial exceptions, in my written testimony, I compare and contrast 2 Federal Circuit decisions. The 2021 decision in UV Apple that invalidated claims on a digital camera under the abstract idea exception, even though the claims require structural components such as lenses and sensors. But a year earlier, in CardioNet, the Federal Circuit reversed a district court abstract idea ruling on claims to a device for detecting and reporting atrial fibrillation, where the claimed components were detectors, logic, and something called event generators. Every useful invention has a purpose that could be described as an abstract idea by analogy to you, but most can be claimed so the subject matter as a whole could be found eligible by analogy to CardioNet. But how can stakeholders predict which approach will be taken? The Patent Office has interpreted Myriad as permitting patenting of natural products that have been modified in a conventional way, such as the cDNA claims upheld by the Supreme Court. But some district courts feel compelled to apply the Mayo-Alice framework to all claims and search for a separate inventive concept. If that approach becomes the law of the land, innovators may not even be able to patent specific formulations of drugs that have been derived from natural products, or any life sciences inventions that do not also involve a new scientific technique. When the judicial exceptions are applied in such an unpredictable manner, the validity of a patent and the value of associated technologies are also unpredictable. 101 issues are considered in potential deals, and unpredictability can be a drag on valuation and impact investment decisions. We know now that the Supreme Court is not going to fix these issues, so it's imperative that legislative action like PARA be taken, and I thank you for your efforts in this regard.
Thank you, Ms. Brinkerhoff. Mr. Johnson.
Thank you, Chairman Coons. Thank you, Member Tillis, Senator Toronto, and the other members of the subcommittee. I appreciate the opportunity to testify today. I'm going to do something really atypical for me, which is go off my prepared script, because otherwise it would sound like I somehow had gotten an opportunity to see your two opening remarks in advance. So let me just say I appear here today in my capacity as chair of the steering committee of the Coalition for 21st Century Patent Reform, commonly referred to as 21C, which is a diverse coalition of American manufacturers who rely on patents to protect their inventions, develop and manufacture products protected by those patents, license patents to and from others in furtherance of their business objectives, and when necessary, assert their patents against infringers, and very importantly, and/or defend against patents asserted against them. Members of 21C are therefore on both sides of these controversies. They are stuck in the middle, and what they want to know is what is going to happen, what is predictable, and what is fair. And they want fairness and predictability above all else, because to run their businesses, they need to know how to make important investments which may take half a decade or more to come to fruition. As many others have stated, the law of patent eligibility in this country now is indeed a mess. No one involved knows in any given situation whether the invention will be eligible or not eligible. And as we've heard, this comes from the Supreme Court's recent activity relating to laws of nature, natural phenomena, or abstract ideas, which was remarkable that they seized on that as the distinguishing characteristic, because they at the same time recognized that every one of the inventions that we have relies to some degree on natural phenomena, laws of nature, or an abstract idea. So now the lower courts are in a quandary. They're denying eligibility to some of our best inventions, including inventions that they themselves see as groundbreaking, breakthroughs, and as you've heard, in many different areas, not just biotechnology and diagnostics, but many other important areas as well. It's important, therefore, that Congress step in now, pass PARA or legislation equivalent to PARA, perhaps changed with wording here or there, as we've suggested in my testimony, but basically pass PARA so inventors and others can understand what kinds of inventions will be eligible, and so that they know where to put their time and effort and where it will be rewarded. PARA accomplished this, as you've mentioned, by prohibiting patentability considerations into patent eligibility determinations. This is the most important area where people make mistakes, and you'll hear it when you hear people talk about it. Just because a patent, an invention, is the kind of invention that is eligible for patenting doesn't mean that it's patentable. And yet you'll see in some of the testimony an equation is reached where they are treated as if they were the same. There are a number of additional criteria. We know them, 102, 103, 112, which must be met. And so we need to maintain this dichotomy and understand this is an eligibility bill. So when someone says this bill is allowing the patenting of X, Y, or Z, well, not necessarily at all. I do agree that it's essential that if we're going to protect our national security and maintain our role as world's technological leader, this area of patent law must be fixed. This is needed to restore critical incentives to the private sector to invest in economic development, innovation, job growth, and everything that comes with it. But what's often overlooked is that consumers will be the ultimate beneficiaries of these reforms. They will not only benefit from the new innovations which come from this stimulated research, but when a new innovation is introduced into a marketplace, it puts pressure on the existing alternatives, and very often prices will be lowered for other alternatives which have now been somewhat outdated. We've seen this over and over in technology. As the next model comes out, the prior model is discounted. And this will help consumers as well for whom those prior models are appropriate. So we need to keep that in mind and to pay attention to this, because this is something that definitely needs to be fixed. I look forward to answering your questions. As you know, in my testimony, I have described this in far more detail.
Thank you. Thank you, Mr. Johnson. I'll begin our first round of questioning. Mr. Johnson, if I might, just to pick up from there, your written testimony points to the Supreme Court's caution in the Alice and Mayo decisions that interpreting its exclusionary principle too broadly could eviscerate patent law, because all inventions at some level may embody or apply natural phenomena, laws of nature, or abstract ideas. How have our courts done at applying the exclusionary principle?
Well, very inconsistently, and unfortunately, I think they have interpreted the Supreme Court decisions in a way which has caused them to overly find ineligibility of deserving inventions. And I pointed to a number of these, but some of them are so plainly unpredictable, things like automotive transmissions and other things that have traditionally been patentable for a very long time, including and some of the things that bear on diagnostics and medicines, such as naturally occurring materials, which are, of course, not patentable when they exist as they are in nature, but which very often are the basis for very important inventions and medicines. And I think I cite to Sherry Knoll's testimony, which provided an extensive list of naturally based drugs. And unfortunately, if you look at the approvals, you'll see the approvals for these kinds of drugs, for one reason or another, dropped off starting about the same time as the Supreme Court cases.
Thank you, Mr. Johnson. I agree with you that the law of ineligibility is indeed a mess, but that is the purpose of our hearing today, is to try and make progress on that. Ms. Brinkerhoff, have the courts applied eligibility law more predictably since our 2019 hearings on the state of patent eligibility? Have they made any significant progress since the constructive and insightful guidelines that were promulgated by the former PTO director?
The short answer is no, except the only predictability that we have is that diagnostic methods are not patentable, but that's not the kind of predictability that we want when we believe that patents promote investment and innovation in these important industries. Literally every time a new decision comes out on 101, we read it with trepidation to see how it's going to be applied in an inconsistent or new way. And I think the cases that I mentioned on digital cameras of all things, or physical devices of all things, show that even the Federal Circuit isn't applying the exceptions in a consistent manner.
Some have argued that current eligibility law is sufficient because although natural products aren't patent eligible, methods of using natural products are still eligible for patenting. Do you agree? Why or why not?
So I disagree, because when the inventor is the first person who's discovered the substance and determined its usefulness, a patent on a specific method of use is not going to reflect or reward the contribution that that person has made. When your patent only covers a specific method, it's difficult to detect infringement and enforce your patent against others, even the limited rights that you have. You can't stop others from selling the product, So you have to police labeling, packaging, marketing materials to see if your patent is being infringed. And for process patents, it can be even more difficult to detect if your process was used. And there's also a number of practical and legal reasons why it can be challenging to obtain specific scope of method claim protection, which actually brings in some of the 112 issues.
Mr. Blaylock, you've testified PARA would impose effectively no limits on the patenting of genes and other natural materials. What about the other sections of the Patent Act, 102, 103, addressing novelty, non-obviousness, and the like, as Mr. Johnson suggested? Wouldn't those finer filters to patentability work to avoid the harms that you flagged in your testimony?
No, Senator, they would not. This is the reason why I concentrated on the concept of biomarkers. These are the biomarkers I'm talking about are being discovered every day. They are therefore new and non-obvious, and it is easy to describe them and how to enable someone to use them, and even to describe the best mode for their implementation. So the rest of the requirements for patentability are real and important to the patent system, but they do not address the concern that PARA would change the current environment and make the patenting of information, of knowledge about an association between a particular genetic anomaly and its clinical significance. Because what would be patented would be merely the use of conventional everyday techniques such as Illumina's-based next-generation sequencing or old-style Sanger sequencing in order to detect that information. It is, so in short, unfortunately, PARA would make a dramatic change.
Mr. Iancu, do you agree with Mr. Blaylock's assessment of PARA? Do you think we need additional legislative language to keep patentability requirements separate, or is that already implied in existing law? Would it have the impact that he's predicting?
No, I disagree with him on that. I think PARA addresses the fact that the pure natural product itself, and the statute says, quote, as such, is not eligible. It's one of the exclusions. As soon as that is applied by human hand and human ingenuity to a practical application, such as diagnosing in a diagnostic kit a particular disease, that is human innovation, and that should be eligible. Whether it's patentable, then we need to decide whether it overcomes novelty and obviousness vis-a-vis the prior art. But it's really important to understand the fundamental concept of what human invention is. All human invention, all of it, is the manipulation of nature towards practical uses by humans on this planet. So we can exclude nature itself, but any human intervention and manipulation, that is what human innovation and engineering is, and that should be eligible for patent. It's the useful arts under the Constitution, and then we can apply the fine filters of 102, 103, 112.
Thank you. Thank you all. Senator Tillis.
Mr. Blaylock, I'll give you 30 seconds to rebut Mr. Iancu's answer.
Thank you. What would be required if you were to proceed with PARA would be to recognize that natural phenomena, natural materials, abstract ideas should be treated as prior art. One should not be able to rely solely on the novelty of some fact about the natural world that one discovers as the basis for privatizing that information and obtaining a monopoly in that regard.
Okay, time. Mr. Iancu, 15 seconds to rebut.
Look, I mean, that is why we have the rest of the code. And any time you apply a practical ingenuity to nature, you're already into the useful arts. It's not necessary to hold it out at this stage. Section 103, we know how to do the analysis. We know how to take the prior art and create combinations and see if it's only a minor improvement or it's using things in the prior art that we already know how to do. That's already there. Put the analysis there. You don't need to keep it out at the Section 101 level.
Okay, thank you. Mr. Blaylock, I Y'all are going to find that I do debate club, ad hoc debate club in this hearing. So if any of you happen to hear something that you take exception to, raise your pen and we'll give you a second to reply. I think it's a productive use of our time. But Mr. Blaylock, in your testimony, I think a lot of people have criticized PARA as something that's going to impede scientific research, innovation, et cetera. I think you may have characterized it as slamming the door shut on innovation. But it seems like, to a certain extent, we'd be aligning ourselves more with policy in Europe that doesn't seem to have had that impact. It seems like academic research is doing well. Diagnostics industry is outcompeting the U.S. Tell me what I'm missing about the policy in Europe and why it's bad there and shouldn't be implemented here under PARA.
Well, Senator, what I would say is we've done the experiment. We have lived with the current state of patent eligibility law for over a decade, and state of science, state of genetic testing industry, generation of knowledge and innovation has not been thwarted. At the time that the Mayo decision came out, some commentators literally and others figuratively announced the sky is falling. The sky has not fallen. We are doing well, and we are continue to outcompete Europe. We draw more VC investment. We are the leading market for new innovations in life sciences. European companies want to come here much more than the reverse.
Ms. Brinkerhoff, does the current state of Section 101 benefit or disadvantage, say, larger or smaller companies?
So I think always the smaller companies are going to be more disadvantaged. First of all, sole inventors and small companies aren't even aware of the state of the law and may invest in their technologies before they discover they're not patent eligible because the lines that courts are drawing are just not intuitive and don't make sense. But also the smaller companies are not in a position to hedge their bets and spread their risks, and they don't have a market power to commercialize products without the investment that is attracted by a
Did you argue, I mean, that some of the challenges, doesn't that really create a weak ecosystem in terms of smaller players or innovators, unless we get this right?
It's absolutely critical that smaller players can get patents on their technology and then count on their patents being upheld. If I can use 2 seconds of my time to respond to just one comment of
I saw your pen raised.
Mr. Blaylock.
An opportunity.
Thank you. So one of his points is that we've had 10 years to see how this all plays out, but I disagree with that because we didn't understand that diagnostic methods would not be patentable until the Supreme Court denied cert in Sequinome, which I think was barely 5 years ago. So we've had patents, like we haven't. It's been much shorter than 10 years, and I am concerned about what we're going to see in the long term once people reckon with the fact that patents can no longer be granted in this technology in the U.S. As you noted, my clients are still able to protect their inventions in Europe and Japan.
Mr. Johnson, Director Iancu, I think, did some good work on guidance in his tenure as director, but I don't think guidance alone is enough now. Do you agree that we really do have to move forward with PARA to actually correct this?
Absolutely. The courts have made it perfectly clear that they are not going to respect the good work that Director Iancu did and that the Patent Office has done. They've worked hard on this, and they feel constrained by the Supreme Court decisions, and until it's fixed by this body, we're going to have trouble.
Thank you all. Thank you, Mr. Chair.
Thank you, Senator Tillis. Senator Hirono.
I'd like to start by thanking the Chairman Coons and Ranking Member Tillis for having this hearing because, as everyone has acknowledged, the Supreme Court decisions in Mayo and Alice have really created a mess relating to patent eligibility, and the hope is that this legislation will provide some level or a lot of predictability to the patent system. So having said that, though, nothing is ever particularly simple. And I did write down that Mr. Iancu said that the manipulation of nature by human beings should be patentable. That sounds very reasonable. Mr. Johnson, I think you mentioned that a lot of things can be eligible, but that doesn't mean that a patent will be forthcoming. So would you say that regarding what Mr. Yanko said, that should be patentable, that goes to eligibility, that doesn't necessarily mean that a patent will ensue?
Absolutely. It may be that the manipulation is not new. It may mean that it's obvious and not worthy of patenting. Or it may be that the invention isn't described pursuant to the requirements of Section 112, and so it may fail for other reasons.
So this is, thank you, because that's what is eligible to be patented. I want to make clear it doesn't mean that a patent will ensue. There are other factors that the Patent Office will
Absolutely
consider. Question for Ms. Brinkerhoff and Mr. Blaylock. So some critics of this legislation, notably the ACLU, argues that it would allow patents for human genes and other natural materials. Proponents of the bill respond that it explicitly makes ineligible patents on unmodified human genes and natural material. But critics reply that there is an exception making eligible any gene or natural material that have been isolated. A question to both of you. What are some examples of genes or natural materials that you expect to be patent eligible under this legislation and that are not eligible currently?
I'll start and I'll leave the genes to you.
Ms. Brinkerhoff?
So some examples, as I mentioned, are isolated. When you discover a chemical from a plant that could have use as a therapeutic agent, that would be a natural product that cannot be patented now, that would be restored to eligibility under PIRA. Other examples are the bacteria that I discussed, where the bacteria may be found in certain areas of the world, like cold-tolerant bacteria may be found in the North Pole, but those are found to have specific useful properties that make them useful in industrial applications, and those would be restored to eligibility under PIRA that cannot be patented now.
Mr. Blaylock, do you think that is reasonable, that the items that Ms. Brinkerhoff has mentioned should be patentable?
I don't, and if I may, I'd like to extend this to the concept of genes, which you also asked about, and to use that example, that if one were to observe newly a particular genetic mutation that is associated with a disease risk, that the question is, how would PIRA make that patentable? Because the only thing that is new is that knowledge. Because isolation, purification, and enrichment are ordinary aspects of conventional genetic sequencing technology. So one would take a blood sample from a human, take an off-the-shelf commercial aluminum machine, and it would isolate, purify, and enrich that gene, and the PIRA would allow patenting that would stop the exploitation of that new knowledge. There is no other human involvement in that other than recognizing the knowledge.
Ms. Brinkerhoff, would you like to rebut?
Thank you. Yes, I think he underestimates the inventive contribution of figuring out that there is a new gene with a new purpose, a new function that hasn't been discovered or known before. So I think that is an inventive act that warrants patent protection.
That's why things are not simple. But I think we all agree at least that the current situation is a mess. So I agree with that. Thank you, Mr. Chairman.
Thank you, Senator Hirono. I'm going to ask just a few questions if either of you want additional, please. Mr. Johnson, you seemed eager to engage in that last round of discussion.
Well, listening to Mr. Blaylock's discussion about the isolated gene, I heard an awful lot about conventional this and conventional that and so on, which would say to me those are novelty or obviousness concerns,
right.
And it may very well be that the isolated gene and what is done with it turns out not to meet those. Right. And that should be enough. It's not What we're worried about, and what he has already acknowledged, is there are some very important things lurking in the genome that could be incredibly important for our well-being in the future. And we should want to incentivize people to look for it and to spend the time and energy and money that is needed in order to find it. And these things don't announce themselves. This takes real hard work and insights and real invention, and we should recognize that. And when that happens, if those inventions are otherwise deserving, they should be patented.
Mr. Blaylock, a logical extension of that back and forth is reflected in your written testimony. You said PARA would prevent people from engaging in research. Would you support this bill if it had an experimental use or research use exemption to patent infringement? Would that move you in any positive direction?
No, it would not, because Invitae would still be concerned that PARA would enable the privatization of information, because there's a difference between discovery of facts about the world and inventions. And Invitae believes that inventions are and should be patentable, but the mere discovery of information about, relevant to human health should not be the sole point of novelty that would enable the patenting of a claim.
So, Mr. Johnson's rebuttal to your previous comments, would Section 102, 103 still not pertain and still not prevent the patenting of something that was mere knowledge but with no novelty, for example, associated with it?
No, it would not, because the hypothetical we're entertaining is newly apprehended knowledge about a particular genetic variant that has clinical relevance. So that particular knowledge, that discernment of that is discovered, is new, and that is what the patent applicant would rely upon to claim, because all the other elements of the claim, the sequencing, the drawing the blood, the counseling the patient, all of that is old. So the novelty and obviousness hurdles would be overcome relying solely on the discovery. And that is the reason why, if you were to proceed with PARA, Invitae would urge the committee to consider a substantial revision, which would renew a line of thought that has been in Supreme Court jurisprudence for a very long time, which is the recognition of natural phenomena, natural materials, abstract ideas as prior art in the examination of patent applications.
Director Iancu, what would the consequences of recognizing that as prior art be?
You're basically eliminating the patent system. Think about this.
And I take it that would be bad.
I do not support that. Again, think about this. Thomas Edison scoured the earth to find the material that would create the light bulb. And he observed, after lots and lots of investment and research and sweat of the brow, that if you take bamboo, okay, and you create a bamboo filament and you heat it up in a vacuum tube, it creates light. That's the knowledge, the information that he observed. Mr. Blaylock says that it's bad to give patents if you observe a genetic mutation associated with a particular risk, such as diagnosing cancer of a particular type, and then you isolate it and create a diagnostic kit. Human beings benefit greatly from that type of, quote, observation. That is the essence of invention. It takes a lot of time, money, and investment to find that out. If we eliminate patents on observing how nature behaves when humans alter it and create new conditions for it, then you eliminate the patent system, because that's what humans do. Engineers use nature and they put them in different combinations to create new technologies. And that's what patents are for.
Thank you. Mr. Johnson, you're going to get the last word in my round, and then Senator Tiller.
Okay. Well, first, as to retarding research, I couldn't disagree more. The fact of the matter is first we have the Hatch-Waxman 271E1 exemption which allows for free research as long as it's related to developing information for the eventual submission to the FDA. But the experience has shown that people who discover and have these inventions don't privatize them. They naturally would like to commercialize them or at least get them spread out and used widely. And in fact, when there have been very dramatic advances done in the biotechnology area, licenses have been made available because it takes a village to do all of the research that's needed in different applications. And these are they're widely licensed on a non-exclusive or product-specific basis. And that ability to become licensed, I want to develop product X using this, then you're willing to invest that money because you know you have the protection of the patent that's behind the license.
If the panel will forgive me, I'm going to run and vote. I am leaving my very capable ranking member in charge of conducting debate club and then moving to the second panel. I will be back as quickly as is humanly possible.
If the panel will forgive me, I don't intend to go vote, so we're going to continue some of the discussion. Mr. Blaylock, I appreciate you being here. I am neither an attorney nor a patent expert. I'm a business person trying to make sure that the United States is set to be the innovation leader, and we already are, to continue that. But not being a patent expert or an attorney that understands patent law, it would seem like Director Iancu's assertion that what you would suggest we do with PARA within the patent system, to me it seems like a bad idea. Why is he wrong?
He's wrong, one, because what I am suggesting is consonant with the current circumstances, because right now one cannot rely upon a natural phenomenon or an abstract idea as the point of novelty in a patent application. The patent system has not ground to a halt. The Patent Office continues to churn out new patents. Patents are upheld on a regular basis. I would say that there is a substantial degree of predictability that has settled into the patent system, and as a consequence, it's a gross overstatement to suggest that would be the end of the patent system, because right now things are operating well, not poorly. And I think those who object are honestly have a different policy outcome. It is not a functional problem. It is a policy difference of agreement. And we would urge the subcommittee to take seriously the possibility that the status quo actually is both tractable, manageable, and serving the country well.
Mr. Johnson.
I'd like to note that we have a fulsome record from the 45 witness hearings, and among those were testimony from the American Association of Universities, the General Counsel of the University of Michigan, who detailed how devastating this was to their activities. We heard from another witness that they had given up looking into diagnostic methods because of this. This is very clearly hurting early stage insights that lead to inventions.
Well, part of what we have here is we don't know what we don't know. I mean, with the status quo, to what extent are we just missing out on the opportunities because we don't have an environment that's worth the investment?
You're absolutely right. And we'll never know what we don't know, but we do know we need what could come from it.
Yeah. Director Iancu, Mr.
Iancu. The current system is not working well. The fact of the matter is that, as the Federal Circuit has observed, the Chief Judge, we have a de facto rule that diagnostic techniques in the United States are not eligible for patent. And that is something that was not considered by Congress, debated in the public square in any way, and it wasn't decided by the United States that that should be the law. Yet that's what the state is in a de facto manner right now. We have a situation where an automobile shaft, an axle, that has particular characteristics that the engineers worked long and hard to determine whether it would reduce vibrations under certain conditions, is not eligible for patent. We don't know what the courts will hold as to the next invention. So the problem we have now, sure, patents are being issued, no question about it. Patents are being upheld, no question about it. But the problem we have is that we have great unpredictability in the court system, and that stymies investment and innovation. And I will say that what Mr. Blaylock is suggesting that I was responding to is a further expansion of that to a very large extent, and codifying that they would apply across all industries, and that is what I think is not a good idea.
Well, I could go on forever. You can see that. Mr. Blaylock, I appreciate you being in the mix here, and I appreciate all of y'all taking my debate club in the manner intended. These hearings are good data points, but they're not where most of the work gets done. So, Mr. Blaylock and those of you in this first panel, I hope that when you see an invitation for work groups and sessions that will go on outside of the hearing, that you come forward. I don't want to impede any successful business that seems to think that the status quo is acceptable. But by the same token, I do believe that we want to make sure that we modernize the system, provide certainty and clarity so that we have more inventions, more creators, and we maintain and I think reinforce our leadership position globally. So I look forward to your continued engagement. Hope you will be at the table. And I appreciate the other witnesses who I've seen before. Mr. Johnson, it's good to see you again. We're going to allow the staff to make a transition for the second panel, and then I will swear them in, and we'll begin with the opening testimony. And if Chair Coons comes back, we'll let him take the gavel back. I'm going to, on behalf of the chair, I'm going to turn to our witness panel introductions, and we'll do a brief swearing in. Our first witness is Adam Mossoff, professor of law at the Antonin Scalia School of Law, George Mason University. Professor Mossoff has published extensively on IP law. Next, we have Mark Dean, operating partner at Lightstone Ventures and co-founder of Foundry LLC, a medical device incubator. Mr. Dean is a co-inventor on 250 issued and pending U.S. patents. Now, then we have David Jones, Executive Director, High Technology Inventors Alliance, a coalition of innovative high technology companies like Google, Intel, Microsoft, and Adobe that was created to advocate on patent policy issues. And finally, we will hear from David Kapos, partner at Cravath, Swain, and Moore, LLP, former Undersecretary of Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office. If you all will stand very briefly so that we can swear you in. Do you swear or affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you all. You may be seated. Professor Mossoff, you can begin.
Thank you, Ranking Member Tillis and members of the subcommittee. Thank you again for this opportunity to speak with you today about the pressing need for reform of Section 101 and why Congress should pass the Patent Eligibility Restoration Act. A decade ago, the Supreme Court created the Alice Mayo Inquiry under Section 101 of the Patent Act. This new legal test converted patent eligibility doctrine into something never before seen in the U.S. patent system. It turned what the Supreme Court once rightly called a threshold test into a major new patentability requirement used prominently by the Patent Office and by courts to invalidate patents at rates never before seen in the 234 years since the first Patent Act of 1790. An empirical study by Robert Sachs found that court decisions applying Section 101 via the Alice Mayo Inquiry jumped 730% after 2014. Between 2014 and 2019, Mr. Sachs found a 1,056% increase in the number of decisions finding ineligible claims and a 914% increase in the number of invalidated patents. These numbers are striking. They are an undeniable confirmation that the Alice Mayo Inquiry caused a revolution in U.S. patent law in ways never before seen by either inventors or lawyers. These unprecedented high rates of the use of Section 101 to invalidate patents have created a legal and commercial quagmire for American innovators. This decade-old legal test on patent eligibility has, at best, spawned uncertainty for inventors. At worst, it is predictable, but only in the knowledge that new and useful innovations will be found ineligible for patent protection, including life-saving diagnostic tests, healthcare treatments for cancer and diabetes, and cutting-edge high-tech innovations such as in CGI and AI. The Alice Mayo Inquiry is now regularly applied by courts in most patent lawsuits. Even worse, courts are invalidating patents on classic industrial innovations that have been long protected by the patent system. As we heard from the prior panel, judges have concluded that an invention on a manufacturing process for making an automobile axle is ineligible for patent protection. But there's more. A drilling process used in oil derricks and even remote-controlled garage door openers have been deemed to be not inventions, called mere abstract ideas that are excluded from the patent system. As I have explained in amicus briefs in these and many other cases, if the same analysis were applied to the classic historical patents that have been affirmed as valid by the U.S. Supreme Court, such as Samuel Morse's invention of the telegraph or Alexander Graham Bell's invention of the telephone, the conclusion would be that their patents were invalid. And this is not hyperbole. The oil drilling patent that was invalidated as an abstract idea emulated the exact same structure and terminology in the patent claim on an industrial process for making rubber that the Supreme Court affirmed as valid in 1981 in Diamond v. Deere. 40 years later, courts now say that this industrial process patent is an abstract idea and thus excluded as such from the patent system. When Supreme Court decisions can no longer be relied on as guiding legal precedent for innovators and lawyers, this creates fundamental legal uncertainty. This chills innovation and undermines the constitutional function of the patent system to promote the progress of the useful arts. The United States has long been a world leader in promoting new innovation with its gold standard patent system. When other countries hesitated, such as at the birth of the biotech and computer revolutions in the 1970s and 80s, the United States forged ahead and secured reliable and effective property rights in new products and services in the growing innovation economy. In fact, today is a special anniversary. Today is the anniversary of Steve Wozniak receiving his patent in 1979 for the first programmable computer that was sold by the Woz and Steve Jobs together through their then new startup called Apple. Under the Alice Mayo Inquiry, Wozniak's patent would likely be invalidated today, as would many other patents at the birth of the computer and biotech revolutions that created massive economic growth and higher standards of living for everyone. Today, the U.S. has closed the doors to its patent system for all innovators. The Supreme Court created this problem with its interpretation of Section 101 in creating the Alice Mayo inquiry, and as has been noted, the court has been unwilling to fix it, repeatedly rejecting tens of cert petitions asking it to do so. And now falls on Congress to reform the patent system. PARA is an important step forward in achieving this necessary reform and returning the United States back to its gold standard patent system. Thank you.
Thank you. Mr. Deem.
Ranking Member Tillis and members of the subcommittee, my name is Mark Deem, and I'm an operating partner at Lightstone Ventures, a Menlo Park-based firm that invests in innovative biotech and medtech companies. I'm also a co-founder of The Foundry, one of the most prolific medical device incubators in Silicon Valley. I've started about 20 medical device companies, and I'm a named inventor on over 250 issued and pending U.S. patents. I would venture to guess that many in this room or your immediate family have benefited from the life-saving technologies that our industry has brought to patients worldwide. You will hear me mention patients a lot during this hearing. I think this is a critical perspective because it fuels everything that we do. To give you a sense of this work, our team at the Foundry was responsible for breakthroughs such as the first system to repair leaking mitral valves in the heart, avoiding major surgery. We also introduced the first devices that enabled doctors through a small puncture in the leg to fish tiny wires deep into the brain to capture stroke-causing blood clots. And none of this innovation, this saving of lives, this restoration of fuller lives would be possible without strong patent protection for our work. I know patent law is extremely complex, and you have many experts here today. I bring the perspective of an inventor, entrepreneur, and investor. One thing that is common when wearing any of those hats is that one is forced to make very difficult decisions that will consume years of our lives and often hundreds of millions of dollars. We evaluate a number of inputs when making these decisions. We obviously need to be reasonably certain that the science will work. We need a strong research and leadership team. We need to understand the market. And critically, we need to know that our inventions can be protected by strong and enforceable patents. On this last point, I believe the U.S. is failing many of our most innovative and disruptive inventors and startups. Consider what we are facing. Nearly all of the top patent officials of the U.S. government, from current and former USPO directors to all the active judges on the U.S. Court of Appeals of the Federal Circuit, have cited their own confusion regarding patent eligibility. If these experts are confused, imagine the uncertainty that this is creating for us, the engineers, researchers, and physicians down here doing the inventing, and for the investors that support us. This uncertainty is costing us cures, treatments, jobs, economic growth, and potentially lives. Here's one example. There are a number of very promising companies looking at high-resolution eye tracking to diagnose conditions like autism spectrum disorder, traumatic brain injury, and treatment-resistant depression. I spoke to some colleagues working in this field, and just last week, one of them received a 101 rejection, claiming that this type of eye tracking could be done by a human, and doing it with a complex camera and computer makes it ineligible. I assure you this is not the case. Imagine you're a clinician staring into the eyes of a potentially autistic child or the eyes of a veteran potentially suffering from PTSD. You're trying to track their eye movements millimeter by millimeter, sector by sector, and you must watch their facial expressions and their physiologic reactions while watching a triggering video. You must process all that information in your brain, comparing it to millions of prior data sets, and then issue a diagnosis in real time. Could you do that? Could anyone in this room do that? I certainly could not. But current patent law says that we could. And so the system being developed to do what we clearly cannot is unpatentable. And now imagine being a clinician able to perform these kinds of diagnoses from hundreds or thousands of miles away, treating patients who otherwise could not receive care. Would you deny those patients care because it was enabled by a computer? I don't think any of us would. This is the problem we are solving for. We need to consider where the U.S. can and must lead, like personalized medicine, AI-assisted therapeutics, AI-assisted diagnostics, and other major needs that will not be addressed if these innovations cannot be patented. I can tell you with certainty that you cannot invest a decade of your life and $250 million of other people's money on an invention that you cannot protect. That model just doesn't work. So I see PARA as not only addressing a current problem, but as key to unlocking future opportunities. My colleagues and I have made it our lives' work to bring new technologies from the minds of inventors to the hands of doctors and to the lives of patients. We fight complex physiology. We fight technological limitations. We fight for investment dollars. We fight to satisfy FDA, CMS, and insurance companies. And since Alice and Mayo, we are also fighting the U.S. patent system. I urge you to pass PARA so that our patent system can support life-changing breakthroughs, not stand in their way. Thank you, and I look forward to your questions.
Thank you. Mr. Jones?
Thank you, Chairman Coons, Ranking Member Tillis, and members, or I guess member of the subcommittee. I never know what to do with that one. I appreciate this opportunity to testify about the Patent Eligibility Restoration Act, or PARA. My name is David Jones. I'm Executive Director of the High-Tech Inventors Alliance, which represents global leaders in areas like AI, quantum computing, software, business software, gaming, computer manufacture, communications, and all sorts of other critical technologies. HTIA members collectively invest more than $165 billion in R&D each year. They provide more than 1.3 million jobs and include seven of the top 20 recipients of U.S. patents. My testimony today will focus on 3 points. Number one, why I'm skeptical that reforms are necessary. Number two, why we consider PARA to be problematic. Number three, what alternative solutions might instead be considered to this problem. Turning to my first point, HTI believes that Section 101 reforms are unnecessary because the current law results in predictable outcomes. That's certainly not the majority view in this room or on this panel, but that is, in our view, what is taking place and what the evidence suggests. A 2020 study by the USPTO that I believe Director Iancu mentioned indicates that both patent eligibility rejection rates and the variability of examiners' eligibility determinations are lower now, or at least in 2020, than they were before Alice, right? So, if you're a patent applicant, at least in those two senses, life got better since Alice than it was before Alice, which seems, I know, counterintuitive. Similarly, the USPTO's quality metrics show that examiners' Section 101 determinations are compliant 98.3% of the time, measured by office actions. By way of comparison, Section 103 obviousness determinations have an error rate that is 4 times higher. Right? The application, at least according to the PTO, the application of 101 is the most accurate of any of the statutory requirements. So consistency and predictability are also evident in the courts. A recent academic study of all Federal Circuit eligibility decisions for about the past decade found that under one of the most well-established metrics for measuring the predictability in the law, Section 101 proved to be more predictable than other areas of patent law. Turning to my second point, HTI is concerned essentially about the same things that I testified about 4 years ago, which you may remember. We are worried that PARA could make almost any human activity patent eligible, and that's of deep concern to us. We are worried about the standard, and one of the most important standards or tests in the bills is this notion of cannot practically be practiced or performed without the use of a machine or manufacturer. In my opinion, that sort of kind of practicality type of test is very unlikely to be any more certain than the abstractness or inventive concept tests that we have now. There's certainly debate over that, but that's my opinion. I think it would be very, very problematic. The test is entirely unprecedented. No one at this point knows how it would be applied or has any experience in applying it, and we think it would lead to less predictable outcomes. The proposed test also appears to extend eligibility to virtually any non-technical process. Under PARA, if a process would normally be considered as a practical matter to require the use of any machine or manufacturer, it would be eligible. We also worry that it could be gamed just by adding on a computer to the claims themselves. And then if you practice the claims, you're necessarily using a computer, and if you're doing something that doesn't use the computer, you're not practicing the claims. You're not actually performing the process. So, I'm going to spare Director Capos 2 examples that he really hates, which are football plays, and we've been over these, including at the previous hearing. I remain convinced that they would be patent eligible. I think that's a bad idea. And the point there is that they're silly, but they show kind of the limits that this could go to. It's everything in between that we're concerned about. So in terms of proposed alternatives, I could imagine 2 ways forward. And one would be a much more targeted approach where we look and see where are the real problems. and then fill in any of those gaps with sui generis protection. That's TRIPS compliant. The United States has done it on, I don't know, 3, 4, 5 occasions in the past, including for crazy things like vessel holes and semiconductor masks and plant patents, I guess, would be another example. The other way that I would propose looking at this is adopting a standard that was explicitly tethered to an advance in technology. And that's what my members really care about. They care that every patent reflects an advance in technology because we believe the patent system is supposed to advance technology. So it's pretty simple in that respect. And those are the two alternatives that at least I can see. I don't know what my members would say to these. I think they generally agree. But those are the two alternatives I could see being useful going forward. Thanks for the opportunity to testify. I look forward to any questions.
Director Kapos.
Yes, good afternoon, Chairman Coons, Ranking Member Tillis, members of the subcommittee. Given what we've heard this afternoon, I'm going to do something that I sometimes do in these situations, which is go totally off script and just speak a little bit about stepping back here. So first of all, on the question of whether the law is broken and whether it's still broken or whether various courts are doing a better job of interpreting it, you actually don't have to go back any further than just the last month to find yet another egregious district court decision. This is in Sarepta versus Regenex Bio case. In a situation where the invention is not at all abstract, it doesn't claim the human genome, it doesn't preempt any part of science, it results from many hundreds of millions, if not billions of dollars of R&D, and yet a district court, and I don't fault the district court, they're just doing the best they can with something that makes absolutely no sense, found the invention ineligible under Section 101. So what does that mean? Well, I don't know what the CAFC is going to do with that appeal. Maybe they'll reverse. Recent history would say they probably won't. But now you've got a company that's got no access to funding because it's got no profit opportunity in the future to continue with bringing the product to market. You've got a message that's been sent that says don't invest anymore in this whole area of R&D to all companies in the field. And you've got exactly what we don't want in this country, which is investment and innovation, effort and dollars moving away from important areas of American innovation. So if you want to know whether the system's broken, it clearly is, it clearly still is. Second thing I would mention, having listened to all the other witnesses so far, is that there is a lot of agreement, a lot of common ground among most of the witnesses. We've got a few witnesses who have a very different point of view, but Mr. Chairman and Mr. Ranking Member, you're aware and your staff is aware that over a period of about 5 years now, a number of us have spent an enormous amount of energy working with you, working with your staff to come up with this legislation, and the detractors have offered absolutely nothing. It's time for them to step forward, and as you mentioned, Senator Tillis, it's time for folks who have their issues to actually propose something rather than just denying that there is a huge problem, which there clearly is. So that would be my second point. My third point would be that PIRA does represent, despite any histrionics, a very practical, sensible approach. Yes, it by definition, as required, includes some words that are words of principle and words that require some court interpretation. But look, our judges in this country are very competent. They're very studious. They know how to interpret words like practical. They've got hundreds of years of experience doing that. And I have absolutely no doubt that they quickly will be able to make the interpretations on top of PIRA that are needed. The one other thing I'd like to mention before hopefully moving on to questions is that any settling of Federal Circuit appeals or data in academic studies that shows that recently the Federal Circuit is not reversing the district courts as much as it once did in this regard is really just a statement about a couple of things that have nothing to do with whether the current law of 101 is really consistent and predictable or whether it is correct. Two different and very important issues, both in their own right. What the Federal Circuit reversal rate has to do with is deference, court deference, and what it has to do with is district courts that have figured out how, and district courts do this, and again, nothing against district courts, it's the right thing. They figured out how to judgment proof or reversal proof their decisions. They do that. The Federal Circuit, which has no basis to reverse and is dealing with complete mess of law, doesn't reverse. And so we end up with the situation that we've got. So with that, I'll say thank you again for listening to me this afternoon, inviting me to be here, and I look forward to your questions.
Thank you, Director Kapos. Thank you to all the witnesses on this second panel. I might, at the risk of reopening a now well-trod ground, Mr. Kapos, if you could just illustrate with an example a claim currently ineligible that would be eligible under PARA compared to a claim that would be ineligible under both current law and PARA. And Mr. Jones has argued that football plays and marriage proposals would be eligible under PARA. Do you agree?
Yeah, starting with football plays and marriage proposals, of course not. The essence of PARA is to provide in this area that an ineligible process, a marriage proposal as an example, does not become eligible because you put a ring on someone's finger. A football dance in the end zone does not become eligible because you spike a football at the end of it. That's the language that was included in the legislation that very clearly says that a claim does not become eligible if unless there's no practical way to perform it without the use of an article of manufacture. And in both of those cases, there is a practical way to perform the invention if it were an invention. So I reject the notion that these silly claims would become eligible. I also hope that we can step back a little bit and recognize that it's absolutely terrible policy to guide our patent laws, something that's very serious to the health and future of our country, by reducing our discussion to trivial, silly examples. We should solve for the real issues involving our patent laws, which are computer-implemented claims, which are claims like the ones going to truck axles and biomedical innovations.
So forgive me for drawing us back to the silly examples. My first part of the question, an example of a claim currently ineligible that would be eligible under PARA.
So claim currently ineligible. So you can go back to some of an easy one, some of the Supreme Court decisions that led us to where we are now. So the claim in Alice likely would become eligible. It is a claim involving a computer-implemented financial machination, I'll call it that has to happen in essentially real time, that is highly integrated into a computer, that could not practically be performed without a computer. So depending on the facts, the Alice case would likely be eligible. Not necessarily patentable, though, of course, because you still have to test against 102, 103, and 112. Giving you a contra-example, Mr. Chairman, the Bilski Supreme Court decision decided as ineligible likely would still be ineligible. The reason there, because in that case, the plaintiff patentee actually stipulated that no computer was required to perform the invention. So they went right down the path of PIRA and said, look, this claim can be implemented entirely by a human being and therefore ineligible.
Mr. Deem, you've testified PARA would clarify U.S. eligibility law by drawing clearer lines as to what is and isn't eligible. How would this help the companies in which you invest?
When we decide what to invest in, or I as an entrepreneur decide what to pursue to try to invent in, we have to weigh out the totality of the risks and the uncertainties. As I mentioned, there's a number of different areas that we have to weigh that out. And when I look back in time prior to these decisions, we kind of knew how to play the game. We kind of understood what was eligible and then what our other obligations were. With that as an additional area of uncertainty in certain of the most exciting cutting-edge technology areas that we want to go into, we just won't go into them. That'll be another uncertainty that we can add on top of the clinical and the financial and everything else. We can certainly decide to stay into a little bit more traditional role with more mechanically obvious types of solutions and invest our time there. So having that clarity and that certainty would open up this area of technology, reduce that particular uncertainty, and allow us to move forward.
Thank you, Professor Mossoff. You identified more than 1,300 inventions that were found eligible in the EU and China, but not in the United States. Do you have any sense for how these inventions might fare under PARA and what impact that would have for our country and our economy?
Thank you, Senator, for the question, and thank you for also raising that, which I did not talk about in my oral testimony, although I do identify it in my written testimony. So this is based upon a data set that was actually collected by Robert Sachs and Dave Kapos of patent applications that have been submitted to the USPTO, 17,000 patent applications. So they spent a lot of time on this, and it identified of those 17,000, 1,300 patent applications between 2014 and ultimately 2019 that had been either faced an initial or final rejection based upon 101 on applying the Alice Mayo inquiry, and then were abandoned by the patent applicant. This is very significant because what makes those 1,300 applications significant, as you mentioned, is that these patents on the same inventions were issued in China and in Europe. And so the clearest signal to entrepreneurs such as Mr. Deem and many others is the United States is closing its doors to cutting-edge innovations. A lot of these patent applications were on healthcare discoveries, and cancer treatments, diagnostic treatments, and treatments of diabetes, breast cancer treatments, and other types of important life-saving inventions.
Last question to you and to Mr. Jones. You testified the PTO's 2019 revised guidelines brought some stability and some certainty back to patent examination. Obviously, that's not statutory. That's PTO direction. Are there parts of that guidance that would be helpful for us to be adopting in PARA?
Yes, thank you, and it's actually excellent because PARA does actually adopt some of the aspects of the very important 2019 patent eligibility guidelines that were adopted by Director Iancu at the USPTO. And in fact, I'm glad you asked that question because Dave mentioned the 2020 study. The 2020 study is based on the adoption of the 2019 patent eligibility guidelines, and so which show you that reform is possible and that reform should happen because it can have a positive effect. And one of those really important aspects of the patent eligibility guidelines is it requires examiners to distinguish between 101, 102, novelty analysis, 103 non-obvious, and 112 disclosure requirements, and it requires them to do them in order and to have an explicit reason if they say something is just a law of nature or an abstract idea to not just assert it because that's actually what is occurring, continues to occur in most courts.
Thank you. I'm going to defer to Senator Tillis. Thank you.
Mr. Chair, one thing, I actually proposed to my wife in the canned goods section of a grocery store in Chattanooga. I would not recommend doing that or patenting it, but I'm going to defer to Senator Blackburn from Tennessee, if I may. I'll come back after Dia.
And there is no response to that comment that you you just made. But thank you. I want to thank you all and the first panel too for the great hearing. You know, in Tennessee, we have a lot of those healthcare patent holders, people that work in autos, some of the Ecotech type engines, batteries that we're seeing, also music. When you're talking about music production equipment and amplifiers and mics for concerts and road tours, we've got a lot of patent holders. And I jokingly, but there's a part of seriousness to this too. I say I can't go to the mailbox without seeing somebody that has some kind of patent that they're working on. But indeed, one of the things they talk about a lot is China. And we hear a lot about how China has led with patent applications. I think it was in 21. They had 1.59 million patent applications. And the other part that we hear about is how they use the PTAB system to come at us and our innovators and our patent holders. And they're trying to leverage that and then invalidate our patents many times. So, Mr. Kapos, I want to come to you. And you touched on this a little bit in your opening remarks, but talk for just a moment about how better patent protection will allow us to more effectively compete globally and hold on to those patents. And then the other thing is when we look at the loss of R&D opportunities that have existed because of this, I think it's kind of the 1-2 punch on a lot of our innovators, and I'd like for you to bring that into your remarks also.
Yeah, well, thank you, Senator Blackburn, and great questions. So starting with competing globally, what PIRA is about is encouraging innovation and encouraging investment in the U.S., right, by way of the U.S. once again having the world's strongest, most effective, most reliable patent system, which we no longer have because of the eligibility mess that we've been dealing with. So PIRA is very centrally about answering your question, enabling innovators in Tennessee to be confident that they can put their talents, right, that's their innovation, and their treasure, that's their economics, to work in the U.S. rather than to have to take it to Europe or to China, where the very same innovations that are not now eligible for patenting in the U.S. are 100% eligible. So coming to the second part of your question, loss of R&D, I'll actually convey an example that I had to deal with that involved an innovator in Tennessee, actually. And this started with a client in Senator Tillis' state, the great state of North Carolina, who called me and asked for advice about investing in a company that is in Tennessee, small startup company, could be one of Mr. Deem's companies that was creating the ability to retrofit automobiles that didn't have self-driving capabilities with self-driving capabilities. It sounds amazing. This is life-saving technology. It's exactly the kind of thing we want to develop in the U.S., highly based on software. And when I looked at the patents involved, I had to conclude they were very vulnerable under Section 101. In other words, they were likely to be found ineligible. So I advised my client from North Carolina, invest in that Tennessee company if you love their management. Invest in that Tennessee company if you love their trade secrets, but don't invest on the basis of their patent portfolio.
Okay, I want to stay with that on PIRA and software because this really affects a lot of the healthcare industry. And one thing we've also found out is it has an impact on quantum. And in August, I did a quantum roundtable with some of our innovators. And this situation came up because there seems to be an ambiguity around that. So when we talk about this bill and the impact that could have and really leading to some specificity, give me just a couple of seconds on that.
Yeah, okay, exactly right, Senator Blackburn. So quantum computing is obviously a transformational technology. It's all about taking entirely new ways of computing and applying them to the most abstract and difficult of problems, like artificial intelligence, et cetera, right? That's exactly the kind of innovation that paradoxically and so unfortunately gets found ineligible under current law because it's deemed to be too abstract. But under PIRA, quantum computing will all be entirely eligible.
Sounds good. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. Senator Padilla.
Thank you, Mr. Chair, and appreciate you convening this important hearing. I apologize I missed panel 1, although we'll have some follow-up with the witnesses in the first panel with questions. But thank you to the witnesses for the extensive testimony that you have all submitted. Now, the understatement of the day is going to be to suggest that this is a complicated and complex issue. And I think it'd be helpful to boil it down, not just for members of the committee, but imagine the public who may be watching from home. And so I want to ask a couple questions through the lens of the particular impact on consumers of what we're talking about here. Now, Mr. Jones and Mr. Deem, you both describe very different outcomes for consumers and innovation about PARA should it become law. Now, Mr. Jones, your members are those in high tech, right? And Mr. Deem, you're approaching this from the perspective of venture capital and investments in the future of the medical device sector. So the question is actually for both of you. What do you predict would be the impact of PARA on consumers? And can you comment on your areas of disagreement? Mr. Deem.
Senator, thanks for the question. The impact of PARA on consumers, I mean, maybe one of the easier places to pick there is in diagnostics and personalized medicine. I think if you look at the future of personalized medicine and diagnostics in general, we know that it's confused under today's guidance. That should be cleared up a lot by PARA. What's the impact on the consumer? Well, one of my business associates recently benefited from personalized medicine, had a condition where it could have been one of 5 relatively rigorous therapy regimens that they would have had to go through, and because of some personalized medicine testing, they were able to rifle shot 1. That made, obviously, their life better, but it also reduced overall healthcare costs. They didn't have to shotgun and maybe go through 2, 3, 4, or all 5 of those therapeutic regimens. And I know of a number of other technologies. A lot of it is in the biotech and genomics types of testing, but on the medical device side, we're seeing a lot of that. So this ability to treat better at lower cost is a real impact of this.
All right, and before I turn it to Mr. Jones, comment on the disagreement you have with his.
I think we have very different industries, and I think that there are, you can legitimately disagree about some impacts between relatively different industries, and frankly, a lot of the arguments get into areas that I'm not an expert on. So,
okay. Mr. Jones?
Sure. Before I bizarrely agree with much of what Mr. Deem said, sorry, I'm not going to fight you so much. I'd just like to say in response to Director Kappas, I would love to see him describe to an East Texas jury how you can run an offensive football play without a football. I'm not a football guy, but as I understand it, it's not just impractical, it's impossible. So I actually agree with a lot of what Mr. Deem just said. The one area, and I covered this in my testimony 4 years ago, the one area where the data does indicate that patents are really, really hard to get, and where it possibly, although it's highly disputed, as you heard on the first panel, it's possible it is negatively affecting R&D investment, is in diagnostics, right? I mean, that's a place where you look at the statistics, and really the 2 areas where the PTO statistics just kind of plummet and never recover are business methods and diagnostics. Everywhere else is doing pretty well. So these look like limited problems, but I actually agree with, can I call you Mark? Most of what Mark, my new friend, just said. So there aren't, I think, huge differences within that like narrow subject matter. I'm sorry.
I got less than a minute left and have one follow-up.
Oh, sorry.
So just a quick comment on consumer impact.
Consumer impact is very complicated, but we believe, and I believe, that it would drive up litigation costs and prices both. So you would have higher prices just in general. And that's what the patent system does. And
so my follow-up then is this from Mr. Jones. In your testimony, you highlight categories of patents that you're concerned would be newly eligible under Section 101 should PARA become law. I'd like to, again, in the interest and through the lens of the folks watching at home, can you provide a single concrete, not hypothetical, a real example of a patent that was deemed ineligible post Alice Mayo that PARA would arguably make eligible that best illustrate your point?
I can provide several, but the easiest one to point to is actually the claim that's reproduced in Director Capos's testimony. We disagree completely on how the bill would be read, and basically the claim, as I remember it, is more or less using automated, like messages, electronic messages go out to people with offers at different prices, and then from the answers, how many people take those offers, you basically draw a demand curve, right? A clear business method patent. I don't see how it would be practically possible to send out electronic messages to digital devices without using a machine. I can't do that without a machine. I don't know if others can. Director Capos reads the bill very differently and thinks that that patent, which actually was asserted against one of my members and invalidated by one of my members, would somehow still be ineligible under PARA, but I'm quite confident it would be eligible. So that's the one I would cite.
Okay, thank you very, very much.
Senator Tillis.
Mr. Deem, I have you mentioned, I believe, in your opening testimony, you were using an example of technology that's tracking eye movements. I think it had to do with either PTS or TBI. Can you go back again, and Mr. Jones, pay attention, because I think you would disagree with that, but can you go back again and talk about why you think that patent would be found ineligible?
That's a very simple answer, because it just was. When I was...
Would you go back just for the,
yeah, sure.
the purpose? I followed it fairly
There's
close.
a whole... Sorry, I was going fast. There was a whole area of technology that's coming out on the medical diagnostic side that's using various types of eye tracking and measuring other physiologic parameters to do tracking, which could be done either directly locally on a computer with a clinician there, or very remotely. And these systems require very complex high-resolution cameras to be doing these trackings. They're often measuring many other physiologic signals. They're doing comparisons and comparing them to databases. And as I was preparing, I thought this is probably an area where we're going to be seeing trouble. I reached out to a few of my colleagues, and the response I got back on Thursday of last week was, I just received a 101 notice that our IP that we're filing on this tracking system is ineligible. So, very concrete answer.
Do you think that's a reasonable outcome, Mr. Jones?
I'd have to look closer at the technology, but it doesn't sound reasonable, does it? I mean, it doesn't. My question, and we discussed this a little bit before the hearing, I looked at the outside counsel's statement that was reproduced in the testimony, and the outside counsel said, well, it's being rejected as an abstract idea, as something that you could do entirely in your brain. I would note that PARA, one of the exclusions under PARA, could you do it entirely in the human mind, right? So if examiners are reading current law that way, it's explicitly reproduced in PARA, so you may have exactly the same problem. The other thing I'd point to is, again, the practically performed test, right? That's subject to misinterpretation. Now, I would argue that his invention, as I understand it, should be eligible under the practically performed test, but it's not clear that that's the case, right, to me, in the interpretation that would be given. So my big concern, again, is that the literal language of PARA seems to, A, not necessarily help the cases that I'm actually really sympathetic to, but B, extend eligibility to things that, in my view and in many people's view, just shouldn't be eligible.
Mr. Deem, do you have any follow-up on that?
If you believe that the language is still ambiguous, I think we just get in there and fix it, because you just agreed that there is a fundamental problem with the types of technologies that are being rejected today that seem like they should be ruled eligible. If you disagree with the language, let's work on tightening that up so that this invention can be patented.
Mr. Jones, I may come back to you. I will tell you that I believe that the Carolina Panthers ran several offensive plays in this season without having the ball in their hands, as evidenced by their record. Mr. Mossoff, I want to go back. What I worry about, not knowing what innovation we're missing. It's a lot like trying to figure out or call the roll by having people who are absent raise their hand. Mm-hmm. I believe that, I think Mr. Deem has been successful. He has scale, so he's probably annoyed with that denial, but he's going to move on and innovate another one and hopefully prevail in that one. What I worry about are no offense, but the young Mr. Deems who who are trying to get started, and that we have barriers to that innovation today. Actually, maybe even those who will someday challenge Mr. Deem in his space. Do you agree that we're missing an opportunity, and do you have any sense of just how profound the barrier because of uncertainty it is to young innovators getting into the space?
Senator, that's an excellent question, because one of the hallmarks of the U.S. patent system, in fact, one of its innovative contributions to all modern patent systems, is to define patents as property rights. We were the very first country to thoroughly do this, to say that once you get a patent, it's a property right. You can go into the marketplace with it. You can use it for venture capital financing. In fact, early innovators like Samuel Morse and Charles Goodyear and others did. It gave birth to the entire licensing system. It gave birth to the franchise business model. And so in this respect, reliable and effective patent rights serve the same function as reliable and effective property rights do in all areas of the economy. And when you secure people in their productive labors, and when you tell them, when you spend time investing in this, whether you're a farmer, whether you're an industrialist, whether you're an inventor, and you will get a property right in it, and you can take that into the marketplace with it and commercialize it and get it into the hands of consumers, which goes to Senator Padilla's question about how consumers benefit from this, then that is what drives successful innovation economies. And in fact, that's been the entire history of the United States. The Industrial Revolution shifted from England to the United States because of our patent system. And the biopharmaceutical revolution, which began in Germany, shifted to the United States in the 20th century because of our patent system. And then by the end of the 20th century, we're not finishing other people's revolutions, we're starting them. The biotech revolution, the computer revolution, and even the mobile revolution, where we're carrying supercomputers in our pockets that we share videos of cats riding Roombas on. Right? I mean, and by the way, our smartphones, that is the most patent-intensive sector of the entire innovation economy, and we buy these devices for hundreds of dollars that are literally supercomputers. So, when you deny these types of protections to innovators, and when you create uncertainty, what you create is the lack of resource, the lack of investments, the lack of willingness to actually go forth and to create these new innovations. And to go to an earlier point that was made in the prior panel very quickly about how, well, people said the sky would fall after the Alice Mayo decisions. Well, the problem here is that a lot of the time horizons on the R&D processes are measured in years, if not decades. Its average is 10 to 15 years between initial discovery of a new molecule and the first sale of a pill to a patient. And so we aren't going to see in the immediate years after a decision the impact of it. But what we will see is in the follow-on years, the lack of new innovations, the lack of new medical discoveries, and the lack of new high-tech innovations.
I frame my concern. Well, Mr. Capos, final word from me. Thank you, Mr. Chair. Any final thoughts?
Oh, sure. So, yeah, thank you, Senator Tillis. So coming back to just a couple of things briefly, this consumer question that Senator Padilla asked, it really boils down to creators of innovation versus consumers of innovation, right? Creators versus recipients or implementers of innovation. So, if you're thinking of a consumer, right, as a party that is taking the innovation from another and implementing it or enjoying it, of course you want prices to be as low as possible, right? And in the short term, taking intellectual property rights away or diminishing intellectual property rights certainly will drive prices down. But the intellectual property system, the patent system, has never been about what's now. It's about what's next. It's about protecting innovation so that investment will occur for the future and consumers will benefit in the future. And that's where the issue of consumer advantage needs to be put into a broader perspective. Ultimately, the innovation that's not created because the patent system isn't there to incent it, right, or to reward it, is the innovation whose price is infinite. You can't get access to it no matter how much you're able to pay, right? And so that's really what we're talking about here. The last thing I would say is coming back to PIRA now in specific. I really do believe that, that you've put together an excellent piece of legislation here. It's practical, it's balanced, it takes into account the legitimate interests of those who are concerned. We're all concerned about not having overbroad or overwrought patents. and PIRA takes those issues into account. If there are remaining points of concern over individual words or disagreements about how some particular claim might get analyzed, that's a perfect place for those who are concerned to now finally come to the table and make their specific suggestions in order to improve the legislation.
Could I just, Director Kapos apparently never read my testimony from the last hearings, which I believe, if I'm not mistaken, had actual red line language. So I just wanted to put that on the record. We have come forward with language. I've suggested all sorts of language. I've been involved with this for the past 5 years and have suggested all sorts of things that haven't been adopted. So, you know, and that's neither here nor there, but I just wanted to put it out there. We have come forward with language. We have come forward with you know, specific legislative language and concepts, and we've spent a lot of time on this. So if there's some suggestion that we're not at the table, that we're not talking about this stuff, that we're not providing suggestions, please talk to your staffs, because I think they are probably very sick of hearing my ideas about how to do this stuff, because...
Two last questions, if I might, Professor Mossoff. Just a lot of witnesses have said the current eligibility law is unworkable. 40 of the 45 witnesses 4 years ago said it was unworkable, said it was a mess. Not everyone, though, agrees Congress needs to act. Are there some stakeholders who benefit from the lack of clarity in the current legal system?
Certainly some stakeholders would benefit in the sense that they may have business models in which they don't create new innovation necessarily, but they rely on innovation that it requires patents to protect long-term R&D investments, and they get easy, immediate access to now inventions that are no longer protected as property rights. So there are, of course, commercial interests, very strong and large commercial interests that actually do benefit from this state of affairs. But the primary drivers of the innovation economy and in fact the drivers of the mobile revolution, 5G and 4G and things of this sort require patents to recoup their R&D expenditures and to license those innovations in the marketplace, just as the innovators did, Thomas Edison and Samuel Morse and many others in the 19th century.
We appreciate the input of everybody who's come to the table, participated, testified. Mr. Kapos, my last question. Some stakeholders have said that PARA doesn't define key terms substantially, practically, and that depending on the meaning courts apply to these words, it may unreasonably be expanded or contracted. Do you share those concerns? How do you think courts will handle language like practically or substantially?
No, I don't have the same concerns. I think this is exactly the kind of language that judges are extremely well suited to interpret. You don't want the legislation to be so tied down that there's no flexibility for judges to use judgment, and using words like practical and substantial are very much designed to enable judges to build case law around the statute over a period of time, as they have in many other places, and specifically in the patent laws. So I have absolutely no doubt that judges looking at PIRA in its totality will do a great job over a short period in putting the additional nuance to those specific words as needed.
Thank you to all of the witnesses on our two panels. My thanks to Ranking Member Tillis and his staff for being great partners. I think today's hearing was important to show both the public and policymakers the Supreme Court's patent eligibility test is currently unworkable, and it's created uncertainty for innovators in high-tech industries, life sciences, reduced investment, made us less competitive. I think it reinforces why the Patent Eligibility and Restoration Act is needed to restore clarity, reliability, and predictability to our vital U.S. patent system. Any member of this committee who wants to submit additional questions for the record, for the witnesses, must do so by 5 p.m. 1 week from today on January 30th. And with that, and my thanks to all who participated, this hearing is adjourned.